My name is Erika Arban, and I am a PhD candidate at the Faculty of Law of the University of Ottawa. Today I am presenting a paper on subsidiarity in European and Canadian federalism, a comparative perspective. One of my research interests is the study of federalism through the decisions of Supreme Courts, constitutional courts. And so today in my paper I will touch upon the principle of subsidiarity, which is an important principle in, at European level, in the European multi-level system of governance. And I would like to touch upon how subsidiarity was dealt with by the Supreme Court of Canada. Subsidiarity is a principle that has always been there in any federal system, in any federal state, but it has become very important, and scholars have started really studying this principle when it was elevated to one of the fundamental principles of European Union law with the Treaty of Maastricht in 1993. So from the early 1990s in Europe, but also in North America, there was a flourishing of literature and scholarship research on subsidiarity. In Europe, of course, because this principle was entrenched in the Treaty of Maastricht, but in North America and elsewhere, because scholars, constitutional law scholars or political scientists were investigating whether it made sense to talk about subsidiarity in federal systems like Canada or the United States, for example. And well, the conclusion that were reached initially in North America were that no, it didn't make much sense to talk about subsidiarity in North America, at least not in the same way as the topic was developed in Europe, because European federalism was in a way different than North American federalism, and also because subsidiarity in Europe was introduced because of the particular nature of European federalism, with member states that had a long tradition, a long history of sovereignty, with different culture, different languages, and so forth. So subsidiarity was the principle that should ensure member states that they were able to keep their powers, even if some other powers were vested in Brussels, so at European central level. In North America, there wasn't much this need of protection for subnational entities. Surprisingly enough, at least in my opinion, very recently, or over the past 10 years, the Supreme Court of Canada has started talking in some of its decisions, started talking about subsidiarity. And I found this very interesting because in this way Canada is moving a little bit towards, or it's learning a little bit the European lesson on subsidiarity. And I did a research on the website of the Supreme Court of Canada to see how many times and in which decisions they were, the issue of subsidiarity was raised. And I did the same research on the website of the US Supreme Court. And from the website of the US Supreme Court, there were no decisions that came up talking about subsidiarity. In Canada, interestingly enough, there were 4 cases that mentioned subsidiarity. Over these past 10 years, the Supreme Court of Canada is bringing up subsidiarity in some of its decisions pertaining division of powers. And it is my assumption that probably in the future this issue will be raised more and more by the Supreme Court. So I think it is very interesting because I think it's a novelty. It wasn't like this before. there wasn't this debate on subsidiarity in Canada before. So I think it will be interesting to see where this discussion brought up by the Supreme Court of Canada will go on in the future.